Good morning. Grace and peace to you in the name of Jesus Christ. Thank you for joining for our latest Learn and Grow seminar, When's the Right Time to Plan? My name is Dustin Petz, and I serve as the president and CEO of the Kansas Methodist Foundation. Throughout Kansas, KMF empowers Methodist churches and ministries, individuals to be good stewards of the resources that we have been entrusted. We're here to help you as a church and as an individual plan well for your future, from legacy giving and investment services to church grants and leadership development. We help us to focus on preparing well for the future. Will you please pray with me? Gracious God, we give you thanks for this day. This is the day that you have made, and we rejoice and are glad. God, we give you thanks for your character of being a generous God, and you created us in your image to be also generous, to be good stewards of the resources that we've been entrusted and to use them to make a difference, to care for our families and to care for the causes and ministries, the church that we love and care about. Help us to plan well, to use the resources entrusted to us, to build up others, to make a difference for our families, to glorify you. We ask and pray your blessing, your spirit upon us today as we meet. In Jesus' name, amen. Presenting on estate planning today will be Randy Clinkscales. Randy founded Clinkscales Elder Law Practice, PA, in 1985. He's a 1980 graduate of Washburn Law School and has represented clients at the administrative, county, state, and federal levels in his 30 plus years of practice. He is married to Barbara Clinkscales, and they have 3 sons. Randy was the first area attorney to become a member of the National Academy of Elder Law Attorneys. He's also a member of the Kansas chapter, serving as its president for 2 terms, as well as the Life Care Planning Law Firm Association and the Elder Law section of the Kansas Bar Association. In 2004, Clinkscales Elder Law Practice began its Elder Center practice, focusing on issues facing our aging population, as well as the caregivers for those who are aging. Randy has co-authored 2 books, What You Really Need to Know for the Second Half of Life, and the other title, Protect Your Family, Don't Write a Blank Check to the Nursing Home. Both are available on Amazon or Barnes & Noble. Randy authors a biweekly column in the Hayes Daily News and Hayes Post, where he writes about legal issues facing older adults and the benefits available to them. He presents seminars for continuing education purposes to healthcare professionals, financial professionals, and attorneys throughout the state of Kansas, as well as at seminars to the public. I'm super excited. Randy is one of our board of trustee members for the foundation. And Randy, we're so grateful for you to be presenting today. Thank you. We hear you joyfully.
Thank you, Dustin. And again, our topic today is, when is it time to plan, or when? I think the other side is, are you too young to plan? Had a couple come see me, I think about 3 weeks ago. They thought they ought to do some planning, that they had reached the age where it was an appropriate time. He was 93 and she was 88. And I said, well, this is a pretty timely time to get something done. Dustin's given you some background of me, so I won't go over this. Practiced in Hayes and Wichita and throughout Kansas. But I think more important for me is really why I do what I do. I am an attorney, but my practice evolved, took a 180-degree turn when I started taking care of my grandmother in about 2001. When I took over her care, she had 3 to 6 months to live. That went on for 10 years. And so, but it was a very joyful journey with her. But a lot of the things that we're going to be talking about here are things that my grandmother and I addressed, and I'll touch on those as we go along. So what I want you to really take away from today is that either you decide or the laws and the government will make decisions for you. And so my takeaway for you is that I want you to get something done. I want you to get some type of plan in place, even if you have to change it later on. It's just really important. If you don't, so let's assume that you don't have anything in place and something happens to you and you lose capacity. Contrary to what a lot of people think, no one has the right to act for you. In other words, just because you're married does not give your spouse the ability to act for you, to make financial or healthcare decisions for you. An exception would be if you are the parent of a minor child. But again, once that child turns 18, you don't have any rights to make healthcare decisions or financial decisions for that child, even if they're incapacitated or have some disability. If you don't have a document appointing someone to act for you and you've lost capacity, then your family is going to have to go through a guardianship that's to make healthcare decisions, or a conservatorship for financial decisions. And just understand that that's going to be paid for by you. It's going to be paid for by your resources. It requires that whoever the court appoints to make decisions for you, there's going to be a bond posted, but that's going to come out of your resources. All conservator and guardianships are much more constricted, much more narrow than maybe a healthcare or a financial power of attorney. So as an example, generally they're not going to allow a conservatorship, which is again, financial decisions. It's not going to necessarily allow for support of a wife or your children to run a business, or as an example, continuing donations. And as you know, in my wife and I's life, our charitable donations are terribly important to us. And so I would want that to continue. I would want there to be continued support for my grandchildren. That's an important part of the planning that my wife and I have, is that we want there to be a college fund or education fund for them, so that they're assured that there are some resources available. Let's talk about if you die without a will or a trust, then the law dictates where your property goes. So if you're married and no children, it generally is going to go to your spouse. Whether your spouse has capacity or not, it's going to go to your spouse. If you're married and you have children, then by law, half of your property goes to your spouse and the other half goes to your children. And so that may not be, so just got to understand if John and Mary are married and they're farmers and he dies, half the property is going to go to his wife and the other half goes to his children, which may or may not be what they want. If there are minor children and you're leaving property to them, then in Kansas, if that child inherits more than $40,000, there must be a conservatorship set up to manage that money. So even though there's a parent alive, the court's going to require a conservatorship. Give you a quick example. A friend of mine's daughter lived with a man for many years. They never got married. They had one child together. He had children from another relationship. He died unexpectedly in an accident. He left, luckily, on his retirement plan and a life insurance money, he left resources to the joint child. But we had to go to court to establish a conservatorship to manage that money for that child. And even though we got to appoint his mother, we ended up spending several $1,000s with another attorney to establish all of that. And again, we had to have to get two attorneys, one for the person filing the conservatorship, and then one to represent the child. If you don't have a will or a trust, and you have minor children with no surviving parents, court requires that there be a court proceeding to establish what's called a guardianship. And that's to appoint someone that's going to have custody and make healthcare decisions and so forth of your minor children. And keep in mind, all of this is going to be paid for by you. It's going to be coming out of your resources. There has to be a bond posted. So again, you're really asking a court to make decisions for you, and not knowing what your wishes are. So the question really is, do you want the law and government making decisions for you? And if not, then it's time to plan. It's just that simple. If you don't want somebody else to make the decisions for you, and guess what they think you would want, then it's time to plan. So I like to break it down into what I call the essential documents. And that's the financial power of attorney, a healthcare power of attorney, a living will, or a will, and then a will versus a trust. And we'll talk about each of these. I will tell you, in my office, probably the most important document that we feel that I need is a power of attorney. And because if a client comes in to see me and they're teetering on health issues or teetering on capacity issues, if I feel like they've got enough capacity at all, then we may sit there and do a power of attorney right there in my office at that moment. If they don't hire me to do something, fine, but at least I've got a power of attorney, because understand that my ability to help a family, the ability of an attorney to help a family many times is, when there's an incapacity issue, many times is going to be, not many times, is always going to be governed by that power of attorney or by a court order. And so the power of attorney can be much broader, grant a lot more powers than a conservatorship or a court can grant or will grant. I could do a whole presentation on powers of attorneys, but Dustin won't let me do that. So I'm going to try to short circuit it just a little bit. In a power of attorney, we're talking about a financial power of attorney, but in a power of attorney, who is going to be the person that's going to make decisions for you when you can't? And that's called your agent. And then we always want a backup agent, because weird things happen. And so in my power of attorney, I go 4 deep. I have my wife followed by my 3 sons, one after the other. You don't have to go that deep, but I always want there to be a backup, because we're going to talk about in a minute, a power of attorney is revoked if there's no backup. So we want to be sure that we have a backup. Let's talk about how much power. So if I give Dustin, if I write out a document and I say, I give Dustin my unlimited power of attorney to do every act in the world and sign it and notarize it. In Kansas, I have left out about 15 powers because in Kansas, contrary to some other states, there are certain things that have to be mentioned in the power of attorney if you want that power to be granted. Now, having said that, not all 15 powers are appropriate for everyone. When I did my son's power of attorney, when he was 34, whatever, years old, it looked a lot different than the power of attorney that I did for my grandmother when she was, I think she was 86 when I first did her power of attorney. Because we have different goals, we have different things we're trying to accomplish. But so just I want to hit some highlights here. To fund a trust, to transfer property in and out of a trust, to make or revoke a gift of property to a trust, to make gifts. So again, I want to give you an example there. In my financial power of attorney, I have a provision in there that my agent can continue to make gifts in accordance with my gifting pattern. So if I have a gifting pattern of giving money to the Hayes United Methodist Church or the Boy Scouts or United Way or whatever, I give my agent the authority to continue on that pattern. If I've traditionally given, which I do, I traditionally give some money to my grandchildren into a special account for their education. I want that to be continued. But I have a restriction on there about other gifting. So I don't want my son, if you will, to be able to gift away the farm. I don't have a farm, but if I had a farm, there's certain limits on what type of gifting he can do. But you can have it so they can change the beneficiaries on your life insurance. If you have pay on death beneficiaries, you can set it up so that they can change that. A couple things, consent to autopsies, make anatomical gifts, alienate a homestead. That's a really big one. In Kansas, you cannot transfer your home with a power of attorney unless that power is specifically in there. There has to be a corresponding consent by a spouse that would allow that to happen. Again, that's actually a constitutional issue in Kansas. Can your agent nominate new agents? That can be really important, because if your backup agent is ill themselves, they may want to go ahead and be on the safe side and nominate somebody that can take their place. You can delegate powers. So powers that cannot be granted in the power of attorney, the ability to make or revoke a will, the ability, now we're talking about financial power of attorney, the ability to make a healthcare power of attorney. They can't do that. Some things that we like to put in there is, and let me get to this slide. Go here. We like to put in there that they must follow your estate plan. So they can't, if your estate plan says, I want 10% of my property to go to a charitable organization and the remaining 90% to be divided among my three sons. the actions of the agent must be consistent with that estate plan. So they can't change all of the accounts so that they all go to one of the kids. They must follow the estate plan. I also like to put in there to whom they have to, I like to put in there that they have to account to someone on an annual basis about what have I done. We like to limit gifts to the agent. We like to put in there who we want to be supported. And again, we talked about the charitable gifts. But let me go back for a couple other things. We do like to authorize access to digital assets. I have investments at Vanguard. I've never met Mr. Vanguard. It's always been online. And so all of that is done through digital access. And so in theory, if something were to happen to me and I didn't have this set up properly, then we would lose access to Vanguard and would have to go through a special process. That would be also like capers, Social Security logins, Medicare logins, and the like. But let me go back for just a minute. So again, sometimes we'll put in there. So as an example, if this is going to be stupid, but if I said I don't want any charitable contributions to go to bars, okay, I could put that in there, and the agent is to strictly follow my intent that's expressed in that document. Again, you can really customize that document to fit your wishes. The other thing is that I want you to understand, and this is really key, a power of attorney is revoked at your death. And so I have a lot of people that come in to see me and their loved one has died, and they have a power of attorney and they're trying to get stuff done. Well, it's revoked. By operation of law, it is revoked at their death. You can always revoke a power of attorney, and there's ways to do that. The power of attorney will be revoked if all your agents are unavailable. In other words, if either they've died or they've lost capacity. You can make some powers survive your death. And those are the ability to consent to an autopsy, organ donation, pay reasonable funeral and burial expenses, and how to dispose of your body. But that must be in the document. So I know these are a little bit gruesome, but I've had a fight before between dad died. The issue was dad died. Is he to be buried by wife one or wife two? And luckily we had a power of attorney that allowed someone to make that decision for me. Otherwise, that was headed for a uncomfortable end. So let's talk about durable healthcare powers of attorneys. And so one of the things that I want you to understand about this is that just because you give someone the power of attorney to act for you when you can't, you do not give up the ability to make your own healthcare decisions. Let me repeat that. Just because you do a power of attorney does not mean you can't make your own healthcare decisions. This only comes into play if you cannot make your own decisions, whether mental capacity, healthy, physical issues, or whatever. But again, what I see a lot of times is people have these cookie cutter type healthcare powers of attorneys when you can really customize those. So let me just share with you my personal one. I about 70% of our clients that we deal with under what we call life care planning have dementia. So I have really strong feelings about dementia and dementia care. And so I have a dementia section in my personal power of attorney that says if I no longer recognize my family, and that's a permanent thing, I describe what type of care my agent can consent to. And basically, I shut down my agent. I say, you can't do certain things for me. If you can't authorize a blood transfusion, no CPR. And again, that's not a right decision. That's Randy's decision. And so to me, it's terribly important that I put that in there. Not only does it give my agent guidance about what I want, it takes the burden off of my agent when they have to make that decision, because they're saying, all I'm doing is I'm following what Dad said. And so it's really important. I have a section in there about quality of life. What's an acceptable quality of life? I have a preference. I put some stuff in there about not using antipsychotics on me if I have dementia. So anyway, you can really customize those documents. I really urge my families to look at those documents fairly often, once or every year, every other year, to see if things have changed, to see if their agents are capable there. I do want to talk one thing about both of these, the healthcare and financial power of attorney. Be sure that your agent knows about it, and be sure you're on the same page. When you look at, there's several famous cases about end of life. There's a Quinlan case, there's a Shivo case, there's a Cruzan case. They're all cases of young people who had catastrophic injuries, and people were trying to make healthcare decisions, and we had competing interests in the cases. The lessons just tell you, the broad lesson from all of those cases is the document's really important, but also having an expression, an oral expression with your agent about what you want is equally as important. You want to get those everybody on the same page. I will tell you, when I redid my healthcare power of attorney and I added some of these paragraphs, I sat down and wrote a letter to my sons and said, Ben's in charge. This is what the document says. Don't give him any crap. Okay. Just this is what I want. This is not Ben's wishes. This is what I want. So anyway, I don't mean to beat this up too much, but again, these are really important documents to me that people really need to get a good handle on. The final document, and I don't have a slide on it before I transition to wills and trusts, is what's called a living will, or in Kansas, actually, the technical name is declaration. And this is generally a document that says the following: if I have a terminal illness that is certified terminal by my treating physician and one other physician, and if a proposed treatment is only going to prolong that dying process, then I do not want that treatment. And so only you can make that. Only you can revoke that. Your power of attorney can't, your wife can't, No one else can. Only you can do that. And so it's an expression of what services that you don't want. And it's binding on your power of attorney. It's binding on everyone. Again, I'm not particularly happy with the language that's in that document. But I have one myself, because I do want my family to be comfortable that I don't want decisions if I'm in a persistent vegetative state and the like. One of the blessings that I had from my grandmother is that when I took over her care, as I mentioned, it went on much longer than what she and I anticipated. And in fact, she was on hospice twice, and then I moved her into assisted living, and she got a lot better, became very interactive and could go to church and that sort of thing. But we had a lot of discussions about end of life, and we did multiple did not resuscitates through the time. But one of the blessings that she gave me was that near the 2 days before she passed away, I was trying to get her to eat something. She was not eating, and she was starting to lose weight. And she said to me, "Honey," she said, "I know I'm dying, and I'm okay with that. I just need you to be okay with that." And I just remember she did pass away 2 days later. When I went to her funeral, I thought how glorious it was that she was able to pass on her own terms. Her biggest battle was trying to convince me. But again, having that conversation with your family is a real blessing, for them. So let me move on to wills versus trust, and this is really our final topic for today. And so let's talk a little bit about a will for a minute. So a will is a document that says what happens to your property when you die. And so it requires two things. First, you have to die. And then secondly, somebody has to take it to probate court and introduce it to court. And then the court has to make a preliminary finding that the document is valid, that it comports with Kansas law, that it is a valid will and testament. And then the court affirms or appoints an executor to manage that estate. That will, and for many years I had a will, tells about how my property is to be divided or is to be distributed on my death. That document is public. Your resources are public. They have to be filed in what's called an inventory with the court. Everything is court supervised generally. There's a couple of exceptions. It is very lawyer in Kansas. It is very lawyer driven. And what I mean by that is that virtually everything is going to be done in the court proceeding. Everything is going to be done through lawyers. And so and that process is going to take anywhere from people say 6 months to a year. We tell our clients at least 9 months to a year. And again, there's some tax stuff that has to be done. So I realistically, it's you're looking at 9 months to a year. You designate in there who your executor is. That's who's going to manage the estate. That's and so forth. Who will do all the stuff, transfer the property, and so forth. But again, it has to do that through court permission. You can designate a guardian of your children, of your minor children. which is a nice thing. You can set it up in there. You can waive a bond. You can name a separate person to manage the money, again, which is a good thing because you can waive the bond requirements. You can waive the right to have to them to have to come back to court every year. If you don't have that, then they have to come back to court every year to get their accounting approved. So again, typically what will happen is you die, somebody takes it to probate court, the court appoints the executor or approves your executor that you put in there. There is what's called a non-claims period where there's a publication in the paper where any creditors have to file a claim. And then the executor has to file an inventory with the court. Then we go through some process there. Then at the end, the executor does what's called a final accounting, provides that to the court and to the beneficiaries. There's a court hearing to approve that. And then at that point, then the court says, how is the property to be distributed? The executor files a document showing how that's to be distributed. And then the court signs off on what's called a journal entry of final settlement, distributing the property, paying the attorney, paying the executor, and so forth. So again, 9 months to a year. Let's talk about a living trust now. We're going to compare those a little bit. And let me just say this for a minute. I've had clients come into my office. I have one client that's an artist, and he has a bunch of artwork. Just, I don't know what we're going to do with it. But he's got certain institutions he wants to leave that art to and so forth. And it really is a great case for a trust, but he wants to do a will. So we're going to do a will, or we have done a will. I have other cases where a simple will might be okay or might be good enough, but they want a trust, and so we do a trust. So there's not a silver bullet here that solves all issues. I will tell you from my standpoint, I prefer a trust. And the reason that I do is it is much, at the end, it's much less lawyer driven than a will. And it's much more, it's quicker resolution, and we don't have the process of going through court. Now, again, some people don't like one or the other, but let me just talk to you a little bit about trust. So a lot of times people call it a living trust. Some people call it a revocable trust. Some people call it a family trust. Those are all names for the same creature. My trust, I think, is called the Randy and Barbara Clinkscales Revocable Trust. So in 2008, my wife and I set that trust up. We then went through a process of what's called funding it. That means we started putting stuff in it. So we put our home in it. We eventually moved our investments in it. We put our accounts in it. I have a law practice, and so I put my stock interest in that trust. Then when we pass away, then the property is distributed according to our wishes. And so in our case, we have a percentage that goes for charitable purposes, and then the balance then is distributed among my 3 children. My youngest child has my 2 grandkids. And so actually that trust gives them a share of their father's share. So my youngest son has not realized he lost a portion of his inheritance when he had kids, but But, I just want to be sure that if something were to happen to him, that we've protected that inheritance for them in case their mother were to get remarried or something happened to her. I want to make the rules for that money. So with a trust, a living trust, my wife and I are the boss. We're called the trustees. We can take stuff in and out of it. There's no tax consequences. It doesn't have a tax identification number. It uses our Social Security number. If I become incapacitated, my wife could continue on with that trust without any interference. If I die, same thing. If my wife and I, we both die, that's only when we have a trustee that will take over for us. And so my oldest son is our trustee. It is private. No one's entitled to see it at all. When I die, my beneficiaries are entitled to see that trust, but there's no court proceeding. At the end, it's much more effective transferring property than the probate process. And I always feel like from an economic standpoint, it's more cost effective. Some neat stuff about trusts that I like is that I can protect beneficiaries. I can, make it so that they don't lose their inheritance. I can provide for the education of my children and grandchildren. I can avoid court supervision. It's amendable and revocable very easily, and it's very flexible. In addition, and I'm going to touch on this again in a minute, but I can, so I want to give you an example. I have a family right now that has a trust. They were sitting on my desk a while ago, but has a trust. They have a percentage of their resources are going to charities. They had 3 charities. Over time, there's been some changes there. And so now we're really down to 1 charity. The point is that all I had to do in their case was go in and amend that paragraph to address that change in their charitable goals. But again, if they change their mind and want to go back the other way, it's real easy to do without having to do a whole brand new will or whatever. I do want to distinguish this a little bit between an irrevocable trust. And so, again, let me be a little bit careful here. Asking about what is a trust is like, or what is the best trust is a little bit asking what is the best pickup. There's a whole bunch of kinds of pickups, all kind of brands, all with different functions. But one type of trust, and again, this is an irrevocable trust. There's multiple kinds of irrevocable trust. Where I see this, and I was just discussing with Dustin a situation a few, I think last week, Dustin, I don't remember, but where a person wanted to ensure that a portion of their estate went to, I think, to the foundation. Yet they were concerned about long-term care costs. And so one of the things that we talked about is putting it into an irrevocable trust. And as long as they did not apply for Medicaid for 5 years, then the resources inside that trust are protected. They can still get the income and so forth. But that way they know that not only is there going to be a charitable contribution, but they know their beneficiaries are going to get what is intended. I use them a lot with businesses, farm trusts, those types of things. So they add asset protection. There are some tax benefits in the long run. It protects from long-term care concerns. You can still change or adjust your beneficiaries, but I mean, again, I had a client in yesterday that wanted to do an irrevocable trust, but I really didn't feel like it was in their best interest to do that. They really needed, because what you put in that trust is in that trust and you can't get it out. And so really just didn't feel like that. I really felt like they needed to keep their property to take care of themselves versus necessarily protecting it for their beneficiaries. And so again, irrevocable trusts are not for everyone, but that's a question that keeps getting popped up. So trust versus will. A will must be probated. It's public, but assets are not required to be retitled. It does not prepare for incapacity. Versus a living trust, which avoids probate. It's private, but you have to retitle asset, which is kind of that's a chore. I always feel like about 75% of our time in a trust is with titling property. It's a lot of issues, a lot of steps, because we're dealing with title companies, we're dealing with different things. So special considerations in your planning: is there business property? There's been a change in the retirement plan rules. Do you have in-laws or outlaws that you're concerned about that we need to protect? We talked a lot with our families about the 4Ds: divorce, death, drug, and disability. How is that addressed in your plan? Are you concerned about paying for long-term care? How to stay at home? Education of children or grandchildren? Charitable intent. Do you want that to be fulfilled during your life after your death? Do you want to establish a legacy? How is that to be controlled? And how is that to be funded? So, Dustin, I am wrapping up here. So what's your next step? Unless you want the government and law to dictate your affairs, then contact an estate planning attorney. So who should that be? I always find that if you have a friend that has somebody that they're working with and they like, that's a good beginning point. Ask in your congregation if there are some estate planning attorneys that people are using that they like. Most of our clients come to us from client referrals. So I know that's an important step, is to find somebody that you can trust. Then call that person and find out if they have some type of free consultation, so that you can at least go in and explore what you're wanting to get done. So I know in our office, we set up a phone call. We have Macy talk with them for a while to make sure we can help them. Then we set up a free consultation with that family. And then based on what they tell us, then we can determine what the fee would be. And I think there are other firms out there that would provide some type of at least an initial free consultation before you commit to anything. The other option that I like is contact the foundation and talk to Tyler, I assume, Dustin. And Tyler can advise and guide you. And if you've got some charitable goals, he can give you some language, even work with your attorney to get in the proper language that allows you to name the foundation or your church or whatever as part of your charitable distribution. But again, it's important to me, and I highlighted this: get your essential documents in place. Don't get stopped by saying, I don't know who my backup will be, or I don't know this, or I don't know that. Just get something in place, and you can change it later. But to get it done now. I mean, to me, it just, if you don't take anything away from this other than the following, it's just get something done now, and then you can visit it again later. Dustin, I'm going to turn it over to you.
Thank you, Randy. This was awesome. We have multiple questions. So one of them is, can you address the relationship of the estate financial size and the question of whether a will or a trust would be the best solution? Does it matter the size of your estate?
Not really. I get more concerned, Dustin, about if there's multiple beneficiaries. And so, if I have a widowed woman with one child, then I'm really comfortable probably doing a will, but setting up her home so it's transfer on death to that one child. When my concern is that a will always invites litigation. And so to the extent that I can avoid, the extent I can close that door, that's why I like the trust.
Tell me, so you described in your power of attorney for financial and I think health both, that you have a single person as a succession of single persons being the power of attorney. Is that recommended, or where you have all three of your boys have to co-sign as powers of attorney concurrently?
I really don't recommend the latter. The issue becomes, it just becomes very cumbersome. Now, I will tell you, sometimes, Dustin, when we have a blended family, so mom and dad each have their own families, that sometimes we'll appoint co-agents, one from each side of the family. Again, that's more of a checks and balance thing, is what we're trying to get done there. But I generally prefer that there just be one agent. But I obviously have done some with two agents or even three agents. But part of the issue, Dustin, is from a practical standpoint. Most banks are not going to follow that. They're going to say, you tell us who's going to sign the check. We're not going to sit here and look for three signatures on a check. We're just not going to do it. And so that really and that's not, I mean, that's kind of nationwide.
Another question is, what about using a corporate trustee?
Yeah, and we do use that sometimes. There are several banks that do that, trust departments that do that. I don't do it a lot. I think I ought to do it more. Anytime there are family dynamics, I think it's a great idea. The issue is going to be, are there enough resources that the corporate trustee would be willing to handle that matter? So we've run into more and more institutions getting out of being corporate trustees because of the size, the estate is too small, and they can't make enough money off of it, because generally they're going to charge a fee based on the size of the resources. So that it's just a consideration. So we have to kind of run it through someone, through the potential trustee, to see if they're willing to do that.
I have a family farm, is what this person says. I have a family farm with multiple generations. How do I pass it down to the next?
Well, the nice thing is that if you can leave that to them at your death, that family is going to get what is called a step up in basis, which is a real tax advantage. One thing that we have to be careful about is that right now the estate tax level is just under $12 million. In 2025, it's going to revert to $6 million unless there's some change there. So I know I'm working with a family right now where their estate right now is not taxable, but in 2025, it will be taxable. And so we're looking at locking in the exemption amount by gifting away some of that property now. As long as we don't gift away more than $11 million, we can do it tax-free. There's some downside on the step up in basis and that sort of thing. But generally, to answer your question, I would pass it by a trust. If you're wanting to protect it, I would look at setting up an irrevocable trust. But I think the issue is always who are you going to pass it to? And are there going to be multiple owners? And how is the ownership going to be managed? And so I know one yesterday was, it's a small farm, and if he gives it to 3 kids, well, then no one's going to be able to farm it. It's not going to generate enough money. So we want to give preference to the one kid that's really wants to farm the property.
Last question. What kind of account do you recommend for grandkids' education?
Dustin, is it a 527? Is that the number?
529 is what
529. I'm sorry.
529.
Yeah, 529 account is what I use for my grandkids, and you can keep control of it, and you can slide the beneficiaries around and so forth. But and there's some tax advantages and so forth. But I do like that, and that's what we're using for our kids.
Yeah, I think there's sometimes concern of putting money in the kids' name, like their own custody account for the purpose of college education, FAFSA, the amount of money they have.
Correct.
Wonderful. This has been superb. Thank you, Randy. We're grateful for your work. And as Randy said, if you would like help, setting up some ideas about charitable giving, or even need help planning a bit before going and engaging an attorney somewhere in your part of the state, we'd be happy to help through our foundation. And Randy often serves well for many portions of the western part of the state, and we're grateful for your presentation. Let me offer a prayer as we end. Gracious God, we give you thanks for your grace and the work that you do to help us to be faithful with the resources that we have. Help us to take this as a directive and encouragement for us to set a deadline soon, so that we can get at least a basic components in place to be able to serve our family and hold to our wishes. We ask that you might lead us as we care and steward the resources that we've been entrusted. Know that you are the owner, and we are the stewards. Help us to do and care for them well. God, we give you thanks in Jesus' name. Amen.
Amen.